You people come from major. Online students, good afternoon. This lesson, I think we have done half many shareholders. We have done half the solutions is also. We can see that I have start right. So maybe now you have forgotten everything. Right? There are some other things in your mind, but we have after the lessons because life has to go on, country has to go on. Okay? Like, anyone affected in this class? Even details. Can use the but we have already discussed about the shareholders. Now we know who is a shareholder. And we know shareholder is interpreted by section 86 to be a shareholder is a person whose name is in the share register or who are entitled to have their name in the share register. And then we have discussed their rights. Like so their rights and liabilities are basically mentioned in the comparison act, articles of association and the common. And they mainly include the right to vote at the election, company meeting, or right to dividend if declared, and right to surplus assets when the comparison widely done. And we also discussed about their liabilities basically in Sri Lanka, and so as in many other countries, the majority, clear majority is the limited liability companies. If the company is a limited liability company, then the shareholders' liability is limited to the shares they have won. However, in while this meeting, their liability is also to be decided according to the Companies Act, articles and the common. As an example, even though we say that shareholders' liability is limited, it is only limited when the company is a limited liability company. If a company is unlimited company, then their liability is not limited. It's almost like that partnership was called the partnership. And also it depends on the type of company. And maybe other contract they have in the company, and they all will decide their liability. And then we also discuss how do they extract their power. In company law, the power of the company is divided between the shareholders and the management. So day-to-day business of a company is run by the board of the directors. We all know it. However, it doesn't mean that they can do anything and everything. So it is well balanced and controlled. Some powers are given to the shareholders by the company. So those powers. So as an example, right to appoint directors, remove directors, and to their remuneration, to anything to make the transaction, to change the company name, to change the articles, to reduce the stated capital. So those cannot be done by the board of directors, so at least they can be done by themselves. So for that, they need the approval of the shareholder. So shareholders exercise their powers at meetings passing resolutions. So I think we have also discussed that they can pass two types of resolution as special resolution and the OD resolution. The OD resolution is generally the method of running the companies. So OD resolution is a resolution passing more than 50%, 51%. We call it simple majority. 51% of voting rights who are entitled to vote and sanction. Basically, almost all the business of the company can be done by passing OD resolution. However, there are some business, as they can materially affect the shareholders and other stakeholders. The law requires those type of business can be done by the simple majority. They need the clear majority. So therefore, they are known as the special resolution. So they are required when there is a material change the comparison. So for as an example, to change the company name, to deduct the stated capital, to change the articles. So those are the 20 the major transactions. So those are required to approve by the special resolution of shareholders. So special resolution is a resolution passed by more than 75% of voting rights who are entitled to vote at such a meeting and with the 15 days prior. And also, I'm not sure whether we have discussed whether it's an OD resolution or special resolution, that also can be done without having a physical meeting by way of written resolution. In comparison, this is mentioned in section 144, known as resolution in lieu of meeting. Under this section, if more than 85% shareholders can give their consent in writing, this is equal to a resolution passed at the physical meeting. So that it does not say whether it is a 51 or 75, it is a 85% shareholders consent is must. And it also doesn't say whether it is a special resolution or OD resolution. If it says it's a special resolution, it would be a special resolution. If not, it is a OD resolution. So I think those are the things that we have discussed so far. So we can start the second part of this lesson today, majority rule and the minority protection. I think we have not discussed, right? Majority rule and minority protection. So majority rule means, in political science, this is also known as the democracy. So that means that the companies are controlled by the majority shareholders. Majority shareholders. Majority means what? Look. Here majority means simple majority, because there's a requirement to pass a order resolution. In democracy, this is also known as a democracy. Right? In the country, president or parliament, they are also selected by majority voting rights. They have more than 51% of voting rights, then they can pass any act in the parliament. And even the president are also selected by simple majority. However, in parliament system or democracy, we don't call it the majority rule because it is said even the opposition is also contributing. It's a system that controlled by all, not by the government. There's an example, many committees, for whatever, the opposition people, the members of opposition parties are also contributing. In many cases, in many committees, presidents are also held by the opposition party. Therefore, democracy means not only the ruled by the government or majority, it is ruled by all. Company law, we call it is a majority rule. Right? So that means simply a requirement to pass the order resolution. Say as an example, if one party, group, or family, or whatever, if they have more than 51% of voting right, it is obvious that they can select the board of directors. There is a board who control the company. This is the reason in business world that all the business parties, they try to acquire more than 51% voting rights in the company. Then they can control the company. Even when even the government sell or whatever, they keep 51% and 49% is given to other party. However, if you have 51%, you can easily control the company. So this is known as the majority rule. So this rule was established by the very classic case known as the First versus Sam. First versus Sam. So for the majority rule, it's obvious that so this rule made it impossible for those in control to use their power against the minority shareholders. This is the case that established the majority rule in UK. A very classic case known as the First versus Sam. It's such a classic case. Majority rule is also known as the rule in First versus Sam. The fact of this case, there was a company. In that company, two directors bought the land. They bought it under their own name. Pay about £50,000. And then sold it to the company for a double price. In fact, it was the island. It was Pet Island they bought. They bought it under their own name for £50,000 and then resold it to the company for £100,000, making 100% profit. So it made huge profit to the two directors and also previously is also the same. It made the interest to the company. Later there was a company meeting. At that company meeting, I hope obviously those two directors are also shareholders. The company passed a resolution saying that even though this transaction made some loss to the company hereby resolved that the company will sue against those default directors. And so those two directors are also in the shareholders' name. They pass a resolution that the company will not file any case against those two directors, even if it made some loss to the company. Right? However, few days later, two shareholders filed a case against these two directors, saying that because of this transaction, they suffered loss. This is the case. What do you think? Whether they are wrong or not, directors. Legally, we don't talk about it. That kind of and the point. Sometimes, even though there are ethical and other things, sometimes court even will not accept the case. When you go to file a human rights case, more than 50% cases are set aside. Human rights case are filed, you go to select they have to grant the leave. But leave it doesn't mean that it is not done. But if the judges believe it is cannot be success and there are some other remedies or if there is a excuse for other party actions, then the court will not accept. They will be set aside. Because they look at the legal now. Right? Likewise, even in this case, court even did not decided to hear the case, the court set aside the case. When court set aside the case, judges have to give the reason for their decision. Judges are bound to give reason for their judgment. So in this case, they have to give reasons. So among the number of reasons they have mentioned, the main reasons are, one main reason was that also we can relate to our first topic, that legal personality was separate. Right? In this case, court, the judges was in the view that if there is a loss, it happened to whom do you think? It happened to the company. It happened to the company as well. Then who should file a case? Then the company has to file a case. Right? But this case was filed by the two shareholders. Right? So court decided that they can file a case under the name of the company, but they have to file a case under their own personal names. The court decided if there is a loss, it happened to the company as well, not to the individual shareholder. Therefore, if it happened to the company, then the proper plaintiff, the proper person to file the case is the company. Outsiders can't file the case. Right? Therefore, court decided individual shareholders are not proper plaintiffs to file the case. The proper plaintiff is the company. That's one of the main reasons for the company to set aside the case. Another reason was also of result of this ground. That was the judges was in the opinion that if in the companies, if individual persons like this want to file a case, in some companies there may be thousands of cases against the same. Therefore, that was also mentioned by the judges, saying that another reason was to stop the multiple cases. If it is some, there are 10,000 shareholders. Therefore, another ground was to stop the multiple cases. Another reason was the judges mentioned that majority has already decided not to file against these directors. So they were in the opinion that court does not deal with the loss and profit of the company. If there is a clear injustice happen, then the court will involve. But they don't worry about the loss and profit. If majority decided that they will not file a case against those directors, then court was of the opinion that the judges have to respect the majority wish. Therefore, another reason was to respect the majority wish. Because otherwise, when you have majority going to decide something, then the minority will file a case. And you can't run the business in that. So, therefore, those are the main reasons for mention to set aside the case. That individual members are not proper plaintiff, to stop the multiple cases, and to respect the majority issue. So after this case, now companies decided that anyway it was decided by the majority by passing all the resolutions. Now companies, especially the English company, believe that majority can do anything. Now court has also affirmed it. Right? Then they started to ignore the minor shareholder. Right? In many business, you know, in a small business anyway, 51% belong to either one party or family or group. In Sri Lanka, I think that it is same even in the public companies. Right? Even in the public companies, if you go deeper, 51% is controlled by there are few people. They were 51. That is why recently, in the 13th Amendment, they also examined about the beneficiary disposal. Because in the PLC, there are those one person cannot have more than 10%. So what they do is they create another company. Right? There is a PLC A by 10% because that's the maximum. Then what he does is he creates a company and his company takes another. Sometimes that company makes another subsidiary and that company takes another 10%. Why four friends take another 10%? Right? Likewise, it is controlled by some group. So that is why recently there was an amendment to the company said that there is a requirement to disclose the ultimate benefit. In some companies, that was about the fifth layer. Right? Some other companies directly that. But you can chart check again the fifth, sixth layer, some other companies will go until the take it. It can know about the some company on gear line. So that's why now you can't do it because there's the requirement to disclose the beneficiaries. That was a very recent event the company said. Right. So anyway, so therefore, even in UK or wherever, the 51% belong to group or individuals of them. So what they did was they completely ignored the minor shareholder. With that, it made huge injustice to the minor shareholders. Because they were not treated as shareholders at all. So then there were so many disputes in the company. There were no smooth running at all. This was the number of cases by the minor shareholders against the majority. This is understood by the judges when cases comes in, and also understood by the Westminster Parliament. Then the Parliament took step to amend the English Companies Act to give some remedies to the minor shareholders. And court also introduced some remedies for the minor shareholders. They were later developed as minority rights or exception to the first versus case. Because still the law is saying companies are run by the majority shareholders, otherwise you can't run the company, right? But the court gave remedies as exception to the first versus case. They were known as the minority rights and developed as a minority rights, or sometimes known as the shareholders' right as a. One of the very early such remedies were remedies under the oppression and mismanagement. Right? So therefore, if the company does not take care of the minor shareholders, if they act in an oppressive manner, so if the major shareholders mismanage the affairs, then the minor shareholders can apply. Then the court took some remedies for it. They were developed as an exception to the first versus case. So following that, even in the Sri Lankan Companies Act, especially the 2007 Act, there are a number of protections for the minor shareholder. So they were first introduced by the common law. Now almost all of them are incorporated to the Companies Act. Therefore, now we can discuss the remedies available for the minor shareholders or shareholders' rights or minor shareholders or minority rights. So we discussed what rights are available under the Companies Act in Sri Lanka to protect the minor shareholder. But still the law is same. Companies are controlled by the majority. Those who have 51% of voting rights. The rationale is then they can pass an orderly resolution. There's a requirement to pass an orderly resolution. But it doesn't say that they can do anything or they can control the company all the manner without or ignoring the minor shareholders because of the rights recognized by the company law for the minor shareholders. Because it is well known that for the smooth running of the business, while you respecting the majority shareholders, you also have to protect the minor shareholders. Then only you can see a simple business. I think this is also common even in the democracy or politics or country as in Sri Lanka is the best example, I think, where we had that more than 35 years long ago. Therefore, even as a country, while you respect the majority securities, you have to protect the minority tenants and Muslims and all. Generally, we can see a smooth running peaceful country. It is common even for the business. While you respect the majority business or majority shareholders, you also have to protect the minority shareholders as well. Then only the business will smoothly run. So now we will discuss what remedies are recognized by the Companies Act to protect the minor shareholders. We directly go to the yes sections. So there are two. I'm not going to discuss them in detail because you definitely will have to go to the lawyers when there are issues. So two such remedies are available under section 224 and 225. 224 is about compression. 225 is about the mismarriage. That anyway, the very long time ago, the English court recognized it. Right? Compression and mismarriage. Similarly, all Pida Kalitesaha, Alka. So, under this section, the procedure is almost same under both. So, if the company affairs of the company are conducted in an oppressive manner on minor shareholders, then those minor shareholders can apply to the court. The court can make orders against the majority. So, under Companies Act, it is not clearly recognized what are the instance of oppression. It is completely given to the court. According to the type of company and merit of each case, the court will decide that there is a oppression. As an example, there's a one time there was a case against the very popular Srilankan company, where that company had the subsidiary. The subsidiary shareholders were 95% shareholder to 1%. There were three shareholders, 2% to another, 3% to another. Right? Those who had 95% shares, right, has completely run the company for other two shareholders who had 5% together, 3 and 2 shares. They were never informed about the company meeting for 18 years. They were never given the dividend. Right? They were never called for the company meeting. Then those two shareholders fight against it. The court decided it completely comes under the oppression. Then court ordered that multinational company in Sri Lanka, that one of the leading company in Sri Lanka, to pay damages and the dividends for all the 18 years for those two shareholders. At the very beginning of company law, when there's a case against the company under oppression and mismanagement, sometimes even court took the step to wind up the company. But nowadays, court will not wind up the company in those matters. Instead, they will give some remedies for those shareholders. What is the oppression will be decided by the court of political merit of each case. And this is other section 225 mismanagement. Again, same procedure, right? If the company's majority or board of directors mismanage the affairs of the company, then again shareholders can attack the court. Then the court can make order against the majority of board of directors. So this is what in fact important for us for both section 24 and 25. You can see a shareholder or shareholders during the 6 months prior to the making of the application constitute not less than 5% of the total number of shareholders. If they have 5% shareholder or head shares, which together carry not less than 5% of the voting rights. It may be either one person or group. If they have either more 5% shareholding or 5% voting rights, then they can apply under these two sections. So 5% means they can apply case against 95%. Really, there's nothing called majority here, right? Majority means 51%. But they may against this. But if they have 5%, they can apply to the court. And the mismanagement, again, the instance mismanagement means sometimes the court have decided that there are some companies where they have appointed directors as they wish without following the closure of the company. According to the company, the company has to appoint directors at meetings passing resolutions. But sometimes there are instances where the directors appointed shareholders as they wish. They have placed their relations without following the proper procedure. The court have decided it is a mismanagement. If they do not follow the closure of the company's articles, right, and if they act as they are not wishing, right, so court decided it clearly comes under the mismanagement. So sometimes we have not called the meetings properly, not have proper voting, right? So they clearly amount to a mismanagement. In such a case, if you have either 5% shares or voting members of voting rights, then they can apply to court. This is not important. Right? That's clearly a minority 5%. But they can file a case against the 90%. So therefore, they are very big for the minority shareholder. Right? So therefore, if a company act in an oppressive manner on minor shareholders, right? Then they transfer shares, they are not informed, there are no annual meetings, right? The proxy matchings and all properly not conducted. The appointment of director shareholders not done according to the Companies Act. They were not informed about the company meetings. They all comes under the oppression and discrimination. Then they have by section 224 and 225, then the court will take a step to protect it. Traditionally, court even took a step to wind up the company. Nowadays, most probably court will not take a step to wind up the company, but definitely those minor shareholders will be remedied. As I told you before, in that case, that two shareholders, they only had 2% each, 2% one and 3% other. Court decided to pay dividends for last 18 years, as they were not called for the meetings. The court decided it clearly comes under the oppression and discrimination. Procedure we don't need to talk, right? So this is another remedy. Recognize the complaints for the minor shareholders known as the first trading holder. In single people, Balak we may have first trading holder. This is section 233, right? Under this section, if the company's conduct that could contravene the articles of the company or Companies Act. Then, under this section, company director or shareholder can make a complaint to the company court. Right? You can see here, this is also important. It says even the shareholder. Right? Maybe he has only 0.1% shares. Right? But they still can file a case against 99%. Right? If the company violate the Companies Act and the Articles of Association, then even a single shareholder can file a case against the company. So very good question for the minor shareholders. In such a case, they cannot say no 51% agreement. Right? With the 1% can file a case. Section 233, restraining order. If the company or board of directors or majority violate the Companies Act or Articles of Association, then even a single member can file a case after this section not to do that. 233 restraining order. Now pretend that there was a company in its articles it has an object clause. Object clause says this company was incorporated to sell shoes. Then where's the object clause? Where do we mention the object clause? Company object clause से कोई तीन? Yes. Is there anyone online? Where's the object clause of the company? Object clause is a part of Articles of Association. Articles of Association, right? So now, Articles object clause says this company was incorporated to sell shoes. Now this company decided to sell chocolate. You were strongly against the chocolate business because 1/3 suffers from the diet. Now what you can do? You have 10% shares in this company. You have 10% shares in this company. Now company is about to start chocolate business. You are strongly against. Now what you can do? 80% shareholders agree to sell chocolate. You have 10%, you are strongly against. What you can do? Do we have to go with the majority? But there's no rule that majority is correct. There's no such a rule. Then what you can do? You have 10% shares in this company. You are strongly against that. So you show chocolate business. Now what you can do? One thing you can do is it is a part of articles. If the company violates the articles, then what you can do? You can file a case under section 232, 233 to restrain entering into the new business. to restrain selling chocolate. You can file a case. Right? Even if you have 10% shares, it doesn't matter. There's no matter whether you have 10%, 1%, or 0.1%. If you are a shareholder, then you can file a case under this section against the company, not to enter into the business. Right? A very good version for the shareholder. You can still protect your rights. So, however, I think I have discussed this section when I discussed about the articles as well. Right? So, now company has already engaged in selling chocolate. Right? Now what you can? This section says order cannot be issued against the company if the business has already been concluded. Because if the company has already started business, then there may be a number of contracts with the company and other parties. Then if you say no, they all outsiders will also be affected. Therefore, court says under this section, company cannot be issued orders by the company if the contract is already been concluded. Therefore, such provisions are there to protect the third parties. But as a shareholder, you have to keep your eye on the company, what they do and so on. So therefore, you can file a case before they entering into the new business. So therefore, it protects your rights. Because as a shareholder, you should know what they were going to do, right? You can't say that you are not aware of so and so, right? So your rights are also protected. You can file a case against the company before they start that business. But once companies is started, then they suffer loss, then you can't file a case. Because that affects the third parties. Therefore, it's such a nice provision, right? In one hand, it protects the rights of the member. On the other hand, it protects the right of the third parties. Because third parties should not be affected by the fault of the company or company's directors. Then what you can do? If the contract is already completed, then the court will not issue any order against the company. Then what you can do? Then you have to agree with others. No. There's no such law. You don't need to. Never ever been promoted. Right? You don't need to do anything against the business. Right? Then there are some other persons, you still can file a case against the directors under section 188. Under section 188, directors also have a duty to comply with the Companies Act and articles. Who made those articles? Who will decide this company was incorporated to sell shoes? Basically, it is drafted by the directors. They cannot be permitted to break their own laws. Right? Therefore, you can sue against the directors and they are liable to pay them. Not the company, right? You can file a case against the company under section 233. You also can file a case against the directors under section 188. However, directors also have a excuse. Because if they have acted for the betterment of the company in good faith, it's the duty of the directors to maximize the profit for the shareholder. Therefore, there are positions in the company that if they can take the approval or consent of 80% shareholders, then directors are also not liable. Directors themselves can do it, but if they have done it with the consent of more than 75% of shareholders, passing a special resolution, or more than 85% of shareholders, passing written resolution, Then directors are also not married. Then what you get? Then you can file a case against the company. You can file a case against the company before they start the business, right? Otherwise, as if affecting the third party's court will not entertain. You can file a case against the directors, then they are liable. However, if they also have done it according to the law by passing special resolution and all, then even the directors are not liable. If they have acted in good faith with the consent of the law by passing special resolution. Then what you have? You are strongly against the chocolate business. But haven't you never done everything? Boyfriend of everything? Haven't you had chocolate? You want to everything. Then you hate chocolate. Then what you can do? Then so that is why minority rights is still there are remedies. Still there are remedies, we will discuss it. And there's another called minority buyout rights. I will explain that at that time. Okay. You can still ask the company to buy your shares for a market price. So therefore, there are number of remedies available for the financial. Just because of you are not the majority, you don't need to keep silence. Right? There are remedies under company section. Anyway, so we have discussed about the occupation and mismanagement. First, we discuss about the minority rights, minor shareholders' rights. So, two rights we have already discussed: occupation and mismanagement. Under these two sections, if shareholders, if they have more than 5% of membership or more than 5% of voting rights, then they can file a case under these two sections against the company. Then the company will take them. So, restraining order is a relief introduced by the Companies Act in 2007 in the form of a corrective injunction. So, that is term that means to restrain wrongful acts which are certain or imminent but have not yet happened. Make a file control act. Not yet comments. But if already comments, then court will not know their case. So court can make orders restraining the company or directors who proposes to engage in a conduct that will contravene the articles of the company or provisions of the company. So this application can be made either by company, director, or shareholder. The basis is the ability of the applicant to show that the company or any officer is about to contravene the articles of the provision of the company. This is another important remedy for the minor shareholders known as the derivative action. We call it derivative action. This is section 234. Section 234. We can discuss our previous law. This remedy, derivative action, is available when the fraudulent transaction or wrongful action is done by the majority. fraudulent action now. Wrongful action is done by the majority. It is obvious that they won't file a case. Right? So, the minority, if law believes that the minority cannot do anything and the majority will control the company, then there will be no cases against those wrongful actions. Right? So this action, derivative action, provides for that remedy. If the majority, if the wrongful action or fraudulent transaction is done by the majority, under this section, even a one shareholder can file a case against. Right? It may against 100,000 people. Right? Therefore, it is also not a right, like a fundamental right case, because you have to file a case and get the deal. If it is strict, if it is possible, if it is feasible, the court will grant leave. So, here, fraud may related to the different matters, maybe fraudulent action related to the corporate property, or maybe result of a reckless, negligent act of the majority or board, or maybe abuse of their powers. So this is known as the wrongdoer control rule, right? Where persons against whom the relief is sought themselves hold and control the majority of the shares and will not permit an action to be brought in the name of the company. Courts allow shareholders to bring an action in order to give remedy for wrong which would otherwise escape redress. Therefore, this is another very good remedy for the minor shareholders when wrongful action or abuse of power or fraudulent transaction is done by the majority. Because of these sections, these remedies that they can't do that. Even though companies are controlled by the majority shareholders, they can't do fraudulent, wrongful transaction. In such a case, there's no majority rule. There are exceptions. Even the single shareholder can fight against. So we have a very good case for this section in Sri Lanka. At that time, it was not recognized by the Companies Act of Sri Lanka. Derivative action was covered in Sri Lanka from 2007 under the Companies Act. But there was a case which happened in 1990s. This is filed by a chartered accountant, auditor, who was also a public litigator, very popular character, Nihanshi Amalasekar, who filed not only this case, but water asset case, Sri Lanka insurance case, also filed by this man, right? Nihanshi Amalasekar, who filed a case against the Mitsui and Company Limited. Mitsui Company was, in fact, in this case, even the Nihanshi Amalasekar versus Mitsui and Company, which is very commonly known as the Hilton case. It is about so-called Hilton Hotel situated in heart of Colombo. A Hilton case in Kerala, right? So Mitsui and Company, right? Mitsui and Company Limited was the major shareholder of the Hilton Hotel. At the beginning, they had 35% shares. Nihanshi Amalasekar had 10,000 shares, which is about 2.1%. Even Sri Lankan government had shares. Right. So in this case, the fact of the case, it's about the hotel that we all know, right? We all have born as a name. Hilton Hotel, Hilton Hotel, everyone knows, right? They can tell me USA, but in Sri Lankan Hilton Hotel, major shareholders were the Japanese company. Right. This came to Sri Lanka in 1979, just after the 1977 UNP government, where they have opened the economy. Then they came to Sri Lanka in 1979, and they started their business. At that time, it was not Hilton, something else. Right. Their name was changed about 2 or 3 times. Hotel developers, so Sri Lanka public goods person. Likewise, they have changed their name. So anyway, they have started in 1979. Mitsui and Company was the major shareholders having 35% shares and main contractors, main architectures, and the main subcontractors. Sri Lankan government was also a shareholder. The government has also been involved. Sri Lanka also a shareholder when 10,000 shares. In that total, it is 0.1%. So they started business in 1979. The name was changed about 2 times. And in 1984, there was some fire in the site. Company was declared open in 1987. And the last meeting before the start was made in 1986. This question was arose in 1986, just before the opening of the business. That was the last business before the operation was started. At that point, Sri Lanka, the company presented their loss provision and everything. So according to the accounts they presented, this company, even if all the rooms were occupied, this company never will reach its projected profit. Right. Is it possible according to account? Right. In Hilton Hotel, now they have done everything. Now it's about to start in a few months' time. Now this is the last meeting before the operation. Everything is done. Then the accountant has done everything. However, even if they believe that all the rooms are occupied, company never ever will make any profit. Take away the good. But that's what happened in the Hilton project. Okay. So in this case, we have Sri Lanka filed a case. This can't be happened. So he filed a case before that. At that time, there was no commercial high court. Then the proper court for the district court. Then he filed a case before the Colombo district court. So then the district court judges decided it is true that there was a case name. Value of a case, there was a question that name. I'm a room make a full kilogata 100%, that never will make its projected profit. Then court accepted the case. Then the Mitsui company, they made the appeal to the Court of Appeal, saying that we have 35% shares. We are strongly against the case. The case is filed by Nihan Amarsegar, who had not even the 1% shares, he only have 0.1% share. Therefore, this case can't be entered because we are against this case. The Court of Appeal decided, oh yes. The parties who have 35% shares are against the case. The plaintiff had not even 1% shares. So that is not reasonable. So they set aside the case. Then the Nihan Sri Amarsegar again appealed to the Supreme Court. Then the Supreme Court affirmed the judgment of the district court judge and said that in this case, even though he had not even 1% shares, he is a minor, still, this case, there was a case. There was a prima facie. Value, well, make another one. Because person can make away the name. So under this type, when there is such a case, it looks like there's something wrongful fraudulent action was done. When there is such case, under English law, even one person can file a case against the government. And the English law is known as the derivative action. So judges decided in Sri Lanka, our complaint law was dependent on the English common law. So until 2007, Sri Lankan complaint law was developed with the English common law. Therefore, court decided English common law is a part of Sri Lankan. As English common law recognized as derivative action, this is also derivative action. Therefore, this case can be accepted in Sri Lanka. Accordingly, Supreme Court ordered the district court to hear the case. Right. So this is the case. Hilton Hotel, I think, even until today, is a huge headache to the country. Right. It is a case spring. Right. About 10 years ago, it is delisted. You can listing here, like the delist. Well, I will the heart of this thing and no return the other. Shareholders of people there, the government leaves it among the cigar. Then we could the paper gardening. Other than the work, you can case whatever. We could under the other, okay, gardening liabilities fail. Sri Lanka Mageta. Happy through Sri Lanka became a few of the load gun and gun like a gun. Some people, I guess, the selling of the Sri Lanka. But the issue is there are no one to buy it. So when they take his liabilities, after find out cigar be selling case for like these carrying out the air. Cannot now the other cigar is to be the I think it's also the same. However, that was the same even in the very beginning. But I'm not the then in this case, the only thing here I can't accept this. It was the Japanese company. So all over the world, there's a respect for the Japanese people. That they are not such people. They are all country tiger on and so there is Japanese name. Police can never country negative. But it is not the business. It is same. Certainly, in this case, court appointed chartered architecture to find out what happened. How they will never reach the project at all. Then only they realized that 2 floors and then 1 basement were missing. Right. That was the reason for them that they never will make a project at all. 2 floors then amount to 78 rooms out of them, 72 double rooms and the 6 management wards. So 78 rooms were missing, that means 2 floors were missing. And 1 basement, that's for the car parking, were also missing. We have ever been the Hilton Hotel. Their basement is not sufficient for the park. So the customers of the Hilton Hotel have to park their cars all the way. Yeah, even the other places of the Hilton Hotel is used for the car park. If not, they would have been used them for any other business. But now they have used them for car park. In the 5-star hotel, there are not be sufficient car parking, but in the Hilton Hotel, they don't have it. So then, it's a very interesting case now, in fact-wise, right? So, but we don't need to discuss it, right? In short, if you want to interested in it, so in this case, when the charter architect was appointed, he knew that 2 floors of the basement were missing. And then the court ordered the Ministry company, both the main shareholder, main supplier, and main architect and engineers. So to present the original plan of the Hilton project. Then their reply was, the original plan was on the site. Then there was a fire in 1984, it was When they ask, the court basically will not accept the copies. But when they say that original were burnt out, the court ordered them to provide at least in the copy. Then the reply was, all the copies were also on the site and they were also burnt out. And they even replied that there were no even a single copy even in the Japan. The Japanese reply was the right. Are you unlikely to believe me? Japan again is people give me even copy and have copy original original site again. Then secondly, court ordered the Colombo Municipal Council to present their copy because in the Colombo Municipal Council area, no one can have any meeting without their approval. Then one person came with a plan which was approved in 1985 and it was an amended plan. Amended plan that Karangan could sit in all. So, a gather again, come to listen to the एक program in Asubai. Asubai is other than right. It started in 1979. The original plan was 24 floors and 2 or 3 basements. Now there's 1 basement missing and only 22 floors. So that was the reason. In that case, in the middle of the case was settled. Fiancé Amalve Sekhar was expelled from the directorate. It's very unfortunate that even the government was a shareholder. Right? So, however, that is the case. What is important for us is that this case was filed by a one person who had not even a 1% shares, but court accepted. Therefore, when the wrongful action, fraudulent action is done by the majority, it is obvious that in this case they will file a case. But still, you can file a case. It doesn't matter whether you are a minor shareholder. The only thing is, there must be a proper case to file a case. So now this is, now there are no, so now this is now recognized by the comparison. In this case, there were no such person in the comparison. Therefore, court accepted it as a common law remedy because at that time, Sri Lankan complaint law was similar to an English complaint law. English complaint law recognized the derivative action. Now it is a regular law, section 234, derivative action. So it says, under this section, application of a shareholder or director of a complaint. Under common law, only shareholder could file a case, but now even the director can file a case, or director or shareholder. So this is important for us. The shareholder. They are the shareholders' right. Minority rights. The court 51% majority. However, under this section, they have to file a case under the name of the complaint. Private name we can give it. Complaint and also court grants leave. Therefore, it is not the right. First, we have to ask for a leave. However, if there is a case, court leave grants leave. So you have to prove that there was a case. That is also good law. Last year, we cannot have done a unnecessary action there. First, you have to prove that there was a case. In the history case, it is proved. 2 floors missing. So therefore, prima facie there was a case in the court granted leave. So therefore, if there is a proper case, even a one person can file a case, but that case has to be filed under the name of the complaint. However, before granting leave, court will look at what they expect and what's the cost of the litigation. Whether the company has already taken any action. So after that, court will decide whether to grant the award. So this is Another remedy available for the minority shareholders, I told you that this is the other remedy available for you, right? Minority buyout rights. Minority buyout rights. Here, in singular we call Sulu Kotasimiange Milidigi Maiwan. So here in this case, she has invested in a company. The company's object was selling shoes. 80% shareholders decided to go for a chocolate business. You are strongly against, you have only 10% shares. Right? The first, you try to file a case under the section 233, restraining orders. However, by that time, company has already entered into the contract with other parties. They have already started comments. Then you can't file a case under that section against the company. Then you file a case against the directors under section 188 for breach of their duties. However, they have also done it with the consent of the shareholders by passing a special resolution. Then directors also cannot do nothing. You can't do anything against the directors because it is also done against the according to the law by passing resolutions. Because law permits the directors to enter the business with the consent of the majority, clear majority, by passing a special resolution. But still you are strongly against. Now what you can do, these are the remedies. Under this section, you can request from the company to buy your shares as well. But one thing is we have to respect the majority. 80% capital, whether it is like or not, we have to respect it. 80% vote are capital, then 100 capital, then whether it is right or wrong is something else. Majority wish, you have to respect it. Right? Convert capital, then majority wish. But it doesn't mean that majority is correct. There's no such a rule. Majority correct rule. So you have a right to go away with the company under this section. You can request the company to buy your own shares. This is a very good section, I think, like either side of the coin. It is good for you because you don't need to go with the people. You don't need to go with that horse because you are strongly against. Everyone should take it down and also it is good for the company asset. Company 80% want to get it done because of the 10%, they don't want to stop their business. 80%, 9% can take care of it. We get it in the business and after that. So they also should be there. So therefore it's good for the both parties. So then you can request the company to buy your own share asset. So this section goes from 93 to 100. Then it says, then what will the company do when you ask the company to buy your shares? Basically, company will try to buy your shares for a very cheaper price. That is also addressed by the law. It says, when there is such a request, then the company should try to buy them. Option to Lanka. Company should try to buy those shares for a market price. They cannot market price. That is also good for both parties. Some people argue that market price is no one knows the market price. It's decided, right? However, it is to be decided by the company auditor. If the company do not happy to pay the market price, then the first company has to pay the price you requested. Then they have to appoint auditor, and then if it's overpaid, you have to pay it back. If it's not, otherwise, the company has to pay you the balance. Right? Therefore, those all issues are addressed. And then it says, company should try to buy them. If company cannot buy it, then the company should try to find a third party who can buy them. The person they can go. If both cannot be done, then the company has to present to the court why they cannot buy. Iko gandula market price, company gandula nang gandula pulang ke kola dentro. It become gandula usawari kamera ayah pelan pelan. Whether they will be bankrupt, they cannot satisfy the soul of the test, so they have to prove why they cannot buy. And then it says they have to buy it for the market price. Therefore, those positions are really good, right, for the minor shareholders, right? So they also, yes, can request from the company to buy the shares. And therefore, it is good for both parties, the company and the shareholder. And also there's another, so there's something called interest group. Before 2007 Act, there's something called class rights. Class rights. So class rights means in compare there are different type of classes. Class of ordinary shareholders, class of preference shareholders, class of creditors, class of debenture holders like us. They are different type of classes. Right? Now that class side is replaced with the interest rate. There's no any other difference. So it is replaced with the term interest rate. So this section says, is the action or decision of the company affect the interest group? If the company's decision affect the preference shareholders, then company has a duty to present it to the preference shareholders first. And if the 75% of preference shareholders agree, then only they can go ahead with that business. Therefore, if any decision of the company affect the class rights or interest group, first it is to be approved by that interest group. Therefore, even in that way, the court, the law try to protect their rights. Right. So, at the end of the lesson, I will upload them tonight or maybe within this week. Then try to answer those questions as well. Right. So, those are the minority rights. So, what we have done today is that basically companies are run by the majority shareholders. Majority shareholders with the shareholders who together have more than 51% of voting rights who are entitled to vote at such a meeting. It's obvious that they control the company because there's a requirement to pass a holding resolution. As an example, they can appoint directors and they can control the company. So this is recognized by the law and courts. And this is also approved by the specific case of cost versus arbitral, where court decided if majority decided something, the court will not interfere. However, later court realized that for the smooth running of business, it is not sufficient to respect the majority decision. You also have to protect the minority shareholders. Therefore, with the intention to protect the minority shareholders, court have introduced a number of remedies. So those remedies we have discussed: opposition, mismanagement, restraining orders, derivative action, minority buyout rights, and right of the interest. Right. So in those sections, the law makes a very good balance between the right of the majority and the right of the minority shareholders. Right. Let's also try to answer those questions as well. So next week, hopefully we can start the capital maintenance. Thank you. Attendance. 18 divided. Yes. The 50 follow that. You're okay with the fraternal? Attendance okay. I'm thinking of starting new lesson because of the major students are not doing so internet so people are some thousand like that. So anyway, we have another half an hour. We have anything that we have done previously to any clarification or whatever. That's the first able to. Shall we start new lesson? We have to start the capital shares and debentures and capital ventures. Comes that? We have another subject. Yes, I going to stay home. Then you try to answer these questions. So you will get a few questions for the exam answer. Clarification there. It's a question, right? So X is the shareholder of the ABC company. X is the shareholder of ABC company. You get a similar question for exam answer, right? X is the shareholder of ABC company. He owns 10% of shares of the company. He owns 10% of the shares of the company. According to the articles of association of the company, according to the articles of association of the company, Company was formed to sell shoes and leather items. Shoes and leather items. However, recently, board has decided to sell chocolate and sweet items. Chocolates and sweets. X is strongly against the new business. So, first question. Explain the remedies available for X. Second question. Explain the remedies available for the board or company. Second question. XYZ company. XYZ company. Second question. This is second question, right? XYZ company recently decided to appoint managing director's son to the board. Managing director's son to the board. MD has 50 shares of the company. Other directors include his wife and a friend. They together have 80% shares of the company. They together have 80% shares of the company. Company has not informed other two shareholders who have 10% shares each. about the company, about the company. And they have not paid dividend for last 5 years. They have not paid dividend for last 5 years. As, as these two only have 20% shares, as these two only have 20% shares, they are in opinion that they have no right to challenge the about decision. They have no right to challenge the about decision. Advise them. Advise my shareholders, advise them. Both come from the topics that we have discussed today itself. Other than I will create at the end of one day. Try to write in a short form, and at form you can write the detailed answers. So you two are traveling. They were not clear. You remain trust. Try something. Right. Right. So our question is that what command is available for X, right? So first in exam, when there's this type of question, the question will be very proper in exam anyway, right? You have to inform me or your examiner that you understand the question. Then you have to, explain that in your own words, what is this question, what topic, and what we expect, right? In this case, you can see, right, something like that. In this case, in this scenario, right, ABC company has incorporated and it has object clause, and X is has only 10% shares, therefore X is a minor shareholder. According to the Companies Act, there are remedies available for the shareholders. And also there are ways where companies can get their business. Then you have to introduce one by one. What's the first one here that the company has? So according to the company's articles, right, the company has a object clause. Right. Now according to section 17, companies are not required to companies are required to act according to the object clause, but it is not restricted. Right. Company can do any business. Right. Therefore, even though company's articles has object clause, there is no rule that company has to limit or restrict its business to object clause. Therefore, company has the right to do business even outside object clause. However, it doesn't mean that X has no limits. According to section 233, if company do any business which is outside of the Companies Act or in contravene the provision of the Companies Act and articles, then as the shareholder, even one person can file a case against the company. Here, the company's object is to sell shoes, but now they sell sweets. It is in contravene of the articles of association of the company. It is against the articles. Therefore, under section 233, as a shareholder, you can file a case against the company to restrain this business. Therefore, the one available for the X is to file a case under section 233, restraining. That's what I'm doing. Then you have to keep it going, right? Then, if the company, however, under this section, if the company has already entered into the business, then court will not order against the company. In such a case, as a shareholder, you also can file a case against the board of directors under section 188. Under section 188, board has a duty to comply with the Companies Act and the articles. So object clause is a part of the article. If the article says this company was formed to sell shoes, it's a duty of the directors to sell shoes. But if they said something else, there's a breach or break of their duties. Therefore, as a shareholder, you can file a case against the directors under section 188. That's another remedy. And again, you also can file a case under section 92 under the minority buyout rights. Under minority buyout rights, even if company has entered into the new business to sell chocolate, after passing special resolution, still you have a right to request from the company to buy your shares as sale under minority buyout right. In such a case, company is responsible to buy your shares and pay you the market price for your shares. So those are the remedies available for it. In simply, Restraining order under Section 230. Breach of director's duties under Section 188. Minority buyout rights under Section 9. So it's only leave it now, right? Take it all. Then the remedy is available for the company. The same thing, right? Under Section 233, if the company has already entered into the new business, then the court cannot order against the company. Because restraining orders can only be filed before the commencement of the new business. This is there to protect the third parties. Right? And then, if the directors or the board enter into the new business by passing a special resolution, then there's no liability of directors. If directors have acted in good faith and entered to the new business with the consent of more than 75% shareholders, with the consent of the special resolution, then the company directors are also not liable. And the company can also pay the market price requested by the shareholder. And the company can buy the new shareholder, or company can buy shares of the X. Those are the remedies available for the company. What is the last one? Leave it now. But don't leave it now, right? So the next question. Right. Okay, one question got here, the companies have set out the procedure to figure out how to appoint directors. Right? And also, the act also set out the provisions how to call a meeting and how to pay the dividends. Right? So if the company do not follow those provisions set out by the Companies Act, it amounts to a oppression and mismanagement. If company, yes, basically directors are appointed by passing resolution. However, without passing resolution, without calling meeting and passing resolution at the meeting, if directors appoint their relations to some other people without following the proper procedure, it is a mismanagement of the affairs of the government. Right? So, therefore, according to Section 225, for mismanagement, the minor shareholders can file a case against the company and can get penalties. And also, it's a duty of the company to inform about the company meeting and send notice to all the shareholders. If they don't follow those proceedings, it is again amount to a mismanagement and oppression. It is the right of the shareholders to get dividends if declared. However, those shareholders, minor shareholders, as they only had 20% share, even though the company can pass resolution without their voting rights, is paid. It's a duty of the company to pay the dividend for every shareholder. So here, the minor shareholders have not paid their dividends, that also amount to a oppression and mismanagement. Therefore, for all those actions, not to pay dividend, not to call meetings, not to send notice, and appointment of the directors without the consent of the shareholders amount to oppression and mismanagement for minor shareholders. Therefore, those minor shareholders can file a case under Section 224 and 225. But you also have to mention, to file a case, the individual should have either 5% shares or 5% voting rights. In this case, as these two parties have 10% each, they have then requirement to find actions. Right? Particularly, they will even write it after you can write after you think it. Particularly. Right, okay, then we will stop for today. Then next week we will start the capital maintenance of the company. Here's a civil question for Excel. So, I have to show you for 2 to 5. Okay.